Hello and welcome to today's webinar, Contracts and Risk Management for Small Business Owners and Entrepreneurs. I am your moderator, Jenny Alton, from the New York Small Business Development Center Central Office. Today's presenter is Dr. Jessica A. Magaldi, Ivan Fox Professor and Scholar of Business Law at Pace University's Lubin School of Business. This webinar is brought to you by the Pace University Small Business Development Center. The PACE SBDC is part of the New York Small Business Development Center network of 22 campus-based centers and outreach offices, which are located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know this session is being recorded. We will share it with attendees after the webinar. Attendees are muted and will not be on camera. Your chats will only be visible to myself, our presenter, and Andrew Flam, Director of the PACE SBDC, who you will see in a moment. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. We will address questions at the end of the presentation. We'll answer as many questions as we have time for today. But for very specific questions that may take more time and detail to answer, or if we run out of time to answer all questions, please reply to the follow-up email you will receive tomorrow to get further assistance from the PACE SBDC, and they can put you in touch with Jessica if needed. And with that, I will now turn the time over to Andrew Flam, PACE Director.
Thanks so much, Jenny. Good afternoon, everyone. Thank you all for joining us this afternoon. Again, my name is Andrew Flam. I'm the Regional Director of the Pace University Small Business Development Center, and welcome to this afternoon's session on contracts and risk management. I want to just briefly review the services that our center and our colleagues from throughout the state offer on a day-in and day-out basis, and then turn the floor over to my colleague, Jessica Magaldi, from Pace University. So as Jenny had touched on, our center is one of 22 located throughout the state. Our team of full-time business advisors provides free one-on-one business advisory services in a wide range of issue areas, such as access to finance, marketing and sales strategies, kind of operational challenges, sort of thinking about kind of structurally how you might kind of be able to operate your business. And then, clearly over these last couple of years, looking at the wide range of pandemic recovery programs that have come out from both public and private sources. Again, all of our services are offered at no cost. We have one-on-one business advisory services and sessions available, both in person here from our downtown campus, as well as virtually if that's your preference. So if you have not yet met with one of our advisors, I would certainly encourage you to do so. And I'll put a link in the chat in a moment that will give you the opportunity to be able to connect with us directly, so we can kind of set that up for you. What I'll also do is put in the chat, I can have a list of upcoming training sessions. Today is an example of the kind of training programs that we offer, bringing in expert speakers, and whether it's us delivering it ourselves or, engaging faculty from our institution or other experts coming in to be able to kind of dig more deeply into an individual topic. And obviously, we're again delighted to have our colleague Jessica Magaldi join us today. And then finally, wanted to make sure that you had kind of a full sense of kind of what we do and how we operate. Again, if you are joining us from other parts of the state, we have counterparts that are located throughout New York State that can be able to offer in-depth analysis and kind of assessment for your business operations wherever you're calling in from. So if you're located here in New York City, we're happy to try and help. If you are dialing from elsewhere, we can also connect you with our colleagues elsewhere. And again, all of our services are offered at no cost. So with that, I wanted to turn the mic over to my colleague, Jessica Magaldi, who's going to lead today's session. And this will be the second of two that she's led for us. And we're always glad to have her back, really being able to look into kind of the operational issues and kind of how you can kind of most effectively manage kind of the contracts and risk management, for your existing or aspiring business. So thanks again, Jessica, for joining us and leading this session. And I'll turn it over to you.
Thanks, Andrew. Thanks, Jenny. It's a privilege to be associated with the PACE SBDC. And yeah, I'm here to talk about contracts and risk management for entrepreneurs and small business owners. I have a few objectives for our session today for you to understand the context of your contracting situation, for you to identify key legal issues, and appreciate the significance of key legal terms, right? You want to identify key legal issues so you know when to seek assistance, and you want to appreciate key legal terms so that you can, if you do have to sign something or have to make decisions, you've got yourself in a better position to do that. So when I say understand these things, general context, language. I know you're not a lawyer, and in many cases you don't want to be a lawyer, right? Many of you who are out there making things happen, don't, have a different mindset than what a lawyer, than what a lawyer brings to the table. But the most important takeaway for you is when you need to call a lawyer, right? So if we can sort of raise your thinking about these things, put it in the front of your mind, then you'll have a sense of, okay, I've got what I need to be thinking about here, but now it's when I need to get legal help. So what's contract, right? A contract's a private arrangement between two or more parties, and it defines the legal rights and responsibilities of a relationship. So sure, I put a couple contracts up here. I use them from some forms that I've got from a relationship that I have, and a lot of these contracts, are, I'm looking at them, they're 15 pages, 18 pages, 25 pages. So it's a powerful idea, like putting on paper all of the rights and responsibilities that a relationship, that will define what the relationship will be. And so when you're thinking about it when your lawyer's thinking about it from a legal perspective, you want to be thinking about it from a relationship perspective. What are the kinds of things that we're going to, that are going to set the expectations for each of our parties. And so it is a powerful notion, this idea, the first thing I said, that's a private relationship, right? You don't need the state to be involved. Two or more parties can just decide that they want to, memorialize the relationship that they have, that they're going to work together within. But you've got, because once it adheres to the requirements of a contract by law, you've got the full force of law, and you can go to court. You can bring the full force of the state to enforce the agreement. So you go to court and you win a judgment. You can have assets seized. You can have wages garnished. You can use the power of the state to get what you should have gotten, or a compensation for what you should have gotten in the first place. And so that's really the nature of it. And what we're looking to do is we're looking to give you the benefit of the bargain when you go to court. We're looking to look into the future and see what should have happened. Not, unravel a contract to bring you back to where you started, and then to compensate you for what should have happened, so that you're in a position you would have been in had the contract been performed as agreed. So, a simple situation where, that one can expect, if you were expecting work to be done by a party on a particular time, you're having someone build your website, you were having them, tile your bathroom, whatever the circumstances might be, you had an expectation that you would pay a certain amount, you would get a certain thing, and it would be done within a certain time frame. And should that not happen, you're not compensated by saying like, okay, well, here's your money back. We'll just go back where we started, because now we might be 2 months, 2 years, some amount of time into the future. And now we're at a disadvantage, having relied upon the promises that we made to one another, and when that doesn't happen. So the law is looking to put you in the position you would have been in. So now when I need to hire someone to build that website on 2 weeks notice instead of 2 months notice, and that person charges me a premium, that's what I want to sue for and get from the party who breached the contract to me. Same thing when I have to, get my bathroom retiled, but I also had to spend a week in a hotel because it wasn't done on time. Those are the costs that I want to recover. So that's this idea that we want to be forward looking, in terms of a contract. We don't want to unravel and go back. We want to get what we expected. So how do we figure out what we expect and what we want? A contract has rights and responsibilities on either party, right? And one party's rights are the other party's responsibilities, and vice versa. So if I'm involved in a contract to buy or sell something and to buy something, then as the buyer, I would expect to pay, which would be my responsibility, and I would expect to receive the goods, which would be my right. And on the other side, as the seller, you would expect to be paid. My right, my responsibility to pay is your right to be paid, and my right to receive the goods is your responsibility to provide those goods. And when you're putting together a contract, you want to think about the fact, this is what I'm calling my SpiderMan role, that the more responsibilities you put on someone, the more rights that you want out of that contract will put more responsibilities on the other party. And that responsibility might come with a price. So I had a client in the early days of my legal career. At the time I wrote this, they were a Fortune 152 company. So I guess if you were, so inclined, you could go look up who it was. But we were building a statement of work for a project that they were doing, a long-term project with a consultancy that was coming in to run their data centers actually at the time. And the individuals from the client that I was working with kept saying, like, can we put this in? Can we have them do this? Can we have them run this? Can we have them do this kind of application development? Can we add this in that we want to do that? And the answer is always, you can add in whatever you want. It's up to the other guy, though, to decide if they want to do that contract on those terms at that price. So you can add in all these things, but it might take longer or it might cost more. So when you're thinking about, what you want to do and what you want to put together, you want to figure out, the best place for you is where you get everything that you need, but not anything that is onerous on the other party for the sake of being onerous, that if you don't actually need it. So no one wants to sue, but a good contract, so a good contract avoids a lawsuit by clearly defining what the expectations are. So the items that you're putting in, the way you describe them, the clarity with which you set out your expectations and the other party's expectations will help you have a sense of kind of where you're going to be in the future should anything go wrong. It's not, lawyers can be super clever about things and slip all sorts of, things in that people don't really understand. But what you're actually looking for is clarity and certainty about what you're doing, so that if we both understand what we're doing, we never have to look at that contract again. And the most important thing of a contract is that it manifests an intent to be bound, that it is two parties with the same understanding of what they're going to be doing, based on a reasonable understanding of the words, that are on the page. Contracts don't need to be formal. There's one of the most famous informal contracts is the Lionel Messi contract, where his dad and his agent sat down when he was 12 or 13 years old and wrote something out on a bar napkin so that there'd be some clarity to it. Does not matter if it is on paper. It doesn't matter if it's typed, doesn't matter if it, is or isn't signed, right? Have the parties manifested an intent to be bound. I'll put a little asterisk and say, there are certain contracts that need to be written. There are certain contracts that need to be signed. But what we're talking about is, have the parties agreed? So in most cases, have the parties agreed? What have they agreed to? What would a reasonable person conclude from the interactions as to whether there's a contract or not? And that standard is, have they demonstrated their intent to be bound to these terms? So lots of things, if a bar napkin counts, certainly emails count, phone calls count, texts count. I just saw a case, I can't remember what state it was in, but where a text was written, and then the thumbs up emoji that you can use in the corner of a text was considered agreement to the terms that were in the text. So you want to be careful how you interact with parties. And when you say, sure, I can do that, or we agree, you want to be thinking about that. You also want to be thinking about your employees, right? And what they might be able to bind you to. Lots of times you will see in the print at the end of a contract a number of things that sort of govern how we interpret these contracts. And one of the ways that we might save ourselves from ourselves is when we have a relationship, to put some safeguards in to say that contract modifications or waivers of performance, where someone says, I'm late, and you say, like, oh, that's okay, or other important communications, that those need to be in writing and signed, and only by you or your top management team. It's a way to kind of save us from ourselves from these things, because the bottom line is, contracts are, except for the few categories of contracts that need to be in writing because of the nature of the contracts and the law, the jurisprudence that's developed around that, because otherwise a verbal contract is just as binding as a written contract. Harder to prove, potentially, but if someone is inclined to prove that, take the time. If there's enough money or something else of value at stake, it can be done. In that circumstance, it's much more difficult to prove what you agreed to. And I'm going to have difference of opinion, and you're going to have a difference of opinion. So without a written document, it's going to be potentially very costly. And I put this little picture up because while I was creating this presentation, I was involved in something where a friend asked if my family could return this book that we had borrowed from her. And I had, I replied with with like a really detailed email about how, like, we had checked everywhere and we didn't have it, and in fact I was sure that we had returned it because we had returned these other things, and this was the day and time that I think that we did it, and all of that. And literally, as I was putting this presentation together, I looked over and there was the book. It was in a basket next to the couch. So memories fail. they're not, we have a absolute positive sense of what we agreed. Also, but we might be wrong about that. And credibility matters. I might look like a person who tells the truth, or I might look like a person who doesn't tell the truth. And that actually does not necessarily change what the truth is, if I look believable or don't look believable. So you're banking on some jury or judge at some point down the line being able to untangle what you were saying, or what you think you meant, or what you said you meant, or what you remembered that you meant. So all that to say, why I bring this up in the beginning is lots of companies that are starting out work without a signed contract. And so there's often a good reason to do that, right? It's more important for you to move quickly rather than stop things, slow things down to get lawyers involved. So if that's the case, then you want to be thinking about like, well, what kinds of things can I clarify in an email or in a conversation, right? So I put together some things, some deliverable due dates, what sign-offs are going to be involved, or who's going to be involved, what the payment timing is going to be, and how we're going to decide if the relationship's complete and done, and we fulfilled our obligations. If you are creating intellectual property, the law might not protect you if you are an independent contractor without a signed writing. So you may lose rights to things that you own. So in that circumstance, I would absolutely never recommend working informally in that situation. Another risk is that if you're the party providing services and you're in a situation where there may be damages, in a formal contract situation, your lawyer would come up with, working with you, a cap on what your potential exposure might be. So if things go wrong, we'll be responsible, but up to $10,000 worth of damages and no more, right? Without a signed contract, your liability is potentially unlimited in that circumstance. And so you can put together, as I said, you can use emails or something like that, but you can also use some kind of letter of intent or a memo of understanding. There's all kinds of things, that are less formal, and they'll prioritize speed, right, over clarity. And there might be an additional, a little bit more risk than you might otherwise have. But if you think that exposure is an acceptable risk, or if you think that it's not actually that risky, then you should move forward with that, with a less formal document. So think about your own business priorities when you're thinking about this. Here are some of the things that have come up for my clients in my practice, right? So someone's going to give you a fee that's, significantly higher than any fee you've ever gotten before. Maybe that's a reason to jump ahead, right? Maybe this client's going to be the tip of the spear, right? They're a new industry or a new type of work or some new vertical that you're going to work in, or there's some kind of, cachet to it, some kind of marquee consideration, right? They're a famous or influential client, or they're well known, or a highly visible location, right? If those are the situations, then that might be the thing for you. And where I come from in this is, you notice that the title of this is, managing, risk mitigation. Actually, I don't remember exactly what I titled it. But that's the context, right? I don't care that you have a contract per se. I care that you have an appropriate level of risk to your business and that you've protected yourself from that perspective. And so, your legal team will be thinking about all of the risks that come to, that possibly could come to bear. But you, on the business or creative side, you decide how much of that risk you want, right? It's your decision. So you shouldn't be forced by your lawyer. You want to have those conversations with your clients or with your partners, whomever you're going to do business with. And then you want to talk to your lawyers and ask them what concerns they see. And then you want to have a document that clearly defines what your expectations are with your parties, from all those perspectives, from a business perspective, a creative perspective, a legal perspective. But you make that ultimate decision. Your lawyer doesn't drive that decision. I have lots of circumstances where I lay out the risks, and then my clients, do what they want. And often they might not take my advice because I'm offering those risks as a general matter, and then they're doing, what I described earlier. They're putting that through the filter of, okay, here are the things that are important to me, and here's what I'm doing. So all that's way of intro to, okay, what's in this contract, and what are the things that we're going to be, talking about. So any contract that someone asks me to look at, no matter what the circumstances, no matter what the topic, I'm looking at these three things first. I'm looking at liability. What are the, how much, if things go wrong, how much could my client be responsible for? I'm looking at, what happens again when things go wrong. How do we get out of this contract? What rights does the other party to have to get out of the contract? And, what happens if we're in a dispute? And then ownership, right? Who owns the products, the software, the reports, that any intellectual property that's coming up here. And we're going to talk about each of these in turn. So liability, right? For liability, we want to think about how to limit it, or when we might have no liability in certain circumstances. We want to line up with subcontractors if we work with subcontractors, and we want to line up with insurance. So I took a little, provision here from a contract, and here we go, right? So speaking to insurance, tying your liability exposure to your property insurance makes you, sure that you're 100% risk insured. So if something goes wrong and you say, we will, if it's our fault, we will compensate you up to the level of what our insurance pays. Now you know that you won't have any exposure. Your insurance premiums might go up, but your risk is capped, and it's capped at an amount where you won't pay anything else out of pocket. So we call that a liability cap. It's one way to limit your liability. You want to limit your contract claims for when a contract is breached, for any other damages that are caused. And one of the things to think about is, who's going to be the party who's most likely to breach this contract. So if I am representing a service provider who's going to go in to a client's email system and migrate all the data from one place to another, and all that data accidentally becomes public, and it's my client's fault, right? The service provider's fault. They're the one who's going to be on the hook for that circumstance. So I want to cap liability in that situation. If I'm representing the customer, then I want a higher cap. And if I'm the customer, I look around and say, well, I can agree to a mutual liability cap. So if you do bad, this amount is what your liability goes to. And if I do badly, this is what my amount, this is what my liability is capped at. I can agree to a mutual cap, especially if I don't think that I'm in a situation, right? If I'm the party who's receiving services, there's not much exposure to me from having a high cap on liability, but it's only to my benefit in that circumstance. Every liability cap excludes intentional bad acts or gross negligence by law, certainly by law under New York. You'll see that contracts still spell that out, just to be clear, and I don't mind that because it sets expectations between the parties. But otherwise, so what we're talking about is parties' negligence. So we're talking about you hire someone to do a job, they do the job poorly, and then their liability gets limited, right? So even if they cause $100,000 worth of damages, if they have a $10,000 liability cap, that's all you'll be able to recover if you're on the other side of that. So you want to think about what that means, and you'll want to be comfortable with that place. And of course, you can always get a higher liability cap. It may cost you more in the negotiations in terms of other trade-offs, or in terms of ultimate, part of why this company might be offering you such a rock bottom price, right, is that they're not willing to take on more liability than they've specified in their contract. So these are the kind of things, with, my SpiderMan role, like, if you want more, you might have to give more, you might have to pay more, you might have to find another provider who's willing to work under those terms. When we cap liability, we can do it with a dollar figure. It's often the value of the contract or a multiple of the value of the contract. We can do a formula, or, as I gave the example earlier, we can say the amount paid or payable by insurance. Another one of the things that we're going to do with consequential damages, going back to that, going to liability, going back to that example from earlier, is consequential damages. So consequential damages are the damages that come not immediately from the breach, but the secondary or tertiary things that happen. So you hire a contractor to work on the roof, and the contractor doesn't show up, and it rains, and the water destroys the top floor, and the walls and the floor all have to be redone, and you need to get another contractor in there. So the damages to get another contractor in are the immediate thing, right? If I contracted to get the roof fixed and the roof wasn't fixed, I need to get somebody in. So if, you know, in the Northeast where we are, the best time to get your roof fixed is in the sort of spring, summer, like that, where won't be where the weather will comply, where there'll be lots of daylight, etc. And so if I do that hiring in February and then my contractor doesn't show up, and I book a time, July 4th weekend, and they don't show up all of July, having to find someone else, and I have to scramble around in July, I might find a contractor who can work for me, but they say, you know what, we're all booked. We were booked up in February, just like everyone else was, but we'll put on a third shift. We'll work on the weekends. We'll work Sunday. So it's going to be 3 times the price. Those damages are the damages that you can appropriately seek. Those are direct damages. Consequential damages are the fact that, when it rained, your things got destroyed inside of the structure. So those damages may not be recoverable unless they're foreseeable. So a quick little example about when they might be foreseeable. They're foreseeable if they are, I would say, a week or 2 out. You still don't, your contractor doesn't show up and the rain comes, but you wait all summer and then you finally call someone in mid-October, and rain comes in October. That would be a consequential damage that wouldn't be foreseeable, right? I'd expect that if you were going to have someone come to fix something where something was due in July, you would have fixed that way before the rainy season comes. So that's a limitation, a consequential damages limitation. You can always recover consequential damages if they're foreseeable. Again, depends what your contracts will say on some of these things, but you'll want to be clear, that things that aren't foreseeable will not be your responsibility. A quick note about subcontractors, if this is your thing, you want to look at your relationship with your subcontractor, and you want to make sure that whatever limitations of liability you have where the subcontractor is limited in what it will give you, that you pass those same ones on to your client, so that you don't have a situation where you owe the client because of the liability provisions in your agreement, but you can't recover from the subcontractor who actually did the work and who actually caused the problem. So there's a bit more to that, but that's the most important thing to be thinking about. So another aspect of liability is indemnity. And so for indemnity, which is one of the options you might have with your subcontractor, but it's also something you might just have in a straight agreement. If your client sues you for an issue with your subcontractor, you will always maintain your liability to the client, but the subcontractor will be liable to you. And you want to be able to go after that party in that circumstance. So what about disputes? What about, when things go wrong and maybe it's time to bring the relationship to an end? So there are 3 things we're going to talk about: how much time you have to bring a claim, how you might want to pursue that claim, mediation, arbitration, or by suing in the courts, and then what happens upon termination. So statute of limitation gives you peace of mind in that there's an amount of time after which you can't be sued for anything related to the contract. And the default rule in New York is 6 years for contracts, but the contract provision can be anything that's agreed upon, by the parties. This becomes particularly important if you are looking to be acquired, or if you are looking to acquire another company, because what you want to do when you are what the acquirer wants to do when they're looking at that target is figure out the value of what they are buying. And in order to do that, they want to look at the benefits, they want to look at the risks. And one of the potential risks in a situation is that someone will sue on a contract, even a contract that's already been completed. And so the certainty comes when the statutory period of time has passed, either 6 years or the period of time noted in the agreement have passed, that's when you know that you have clarity that this is not, going to be something that's going to come back to you. On the other side, right, if you are thinking of suing under a contract, you want some period of time after the agreement has been completed, because maybe the work's done, but the flaws don't show up until later. So you want, that period of time. So that's how the laws come to 6 years. But again, shorter or longer is as the parties decide, given the subject matter, given the nature of the relationship, etc. So what to do? Do you go to court? Do you go to arbitration? Should you mediate? Here's a little provision, an arbitration provision from this contract, but it's a little tiny. So I'll just, return back here and say, so usually the question is arbitration versus litigation. And the most important thing, so the concern that people have around arbitration versus litigation is they want something speedy and they want people who are knowledgeable. Mediation's an alternative that can be attempted separately, either in addition, like at first, and if it gets you where you need to be, that'd be great. It's always a good idea to before you're even, so it's a good idea to have contract provisions that protect you, but really what you're looking to do is have a conversation about expectations and what went wrong and how to fix it. And usually informal mediation is the first thing that anyone tries, really. But you can always do mediation, which is where you're just asking a third party to come in and help you to come to terms between yourselves without, needing a formal process. So that aside, then arbitration versus litigation. It's good to arbitrate if you think that you have a subject matter that is very technical and you'd like to make sure that someone who's hearing your case is familiar with that subject matter, and you don't want to spend the time to educate them. We've got like Supreme Court justices who don't know how to text, who don't know how to use email. So if you've got a complex technological question, you might seek to make that have an arbitrator make that decision for you. The key circumstance with arbitration or litigation is, litigation is a formal process. You go to court and there are, certain things that must happen. Arbitration, you can build it however you want. And this is another one of these situations where we've got kind of the more things we put into it, then the more time it might take. So one of the benefits of arbitration is that it can be speedy. Litigation, if we were on a television show, someone has a dispute and then there's a commercial and then they're in court, right? After the 3-minute commercial is over, in real life, it takes 2 years potentially to be in court on a contract dispute. 2 years of you, waiting and, in limbo while you're trying to run your business. So people like arbitration because they feel like it's fast. You can decide how it's going to work. You can say, we're each going to pick an arbitrator, and those arbitrators are going to pick another, and that team of 3 arbitrators is going to make the decision. Or we're going to use an arbitrator from, the professional group that we both belong to, because we trust that they're going to be able to, come to a resolution. But then the more people start to think about it, well, wait, I want to present evidence. Well, maybe we should have some rules around what they should do. Okay, well, maybe I'm going to present witnesses. How can we do that? So you might bulk up your arbitration process, and it might be just as time consuming as litigation. So you've got some choices in how you do these things. The most important thing I would say to think about is to make sure that you either don't choose venue or that you choose a venue that you're comfortable with. I actually have a client right now where we are disputing whether, we are disputing in our contract negotiations what to do in the event of a dispute, and the other side wants venue in California, meaning no lawsuit or arbitration can happen except physically in California. My client's based in New York, in Westchester, and so they are not as interested in binding themselves to California, right? So that they have to fly themselves, they have to fly their witnesses, out for however many depositions or court proceedings that there might be. So you can be silent as to venue, and then the first party that sues, who can make a credible case that it should be in the court near where they are, that's where the case would be. Or if you're going to define it in advance, you want to think about whether you can be to that location and what kind of a burden it may be, right? If you've got a $20,000 contract dispute, but you have to keep flying to California in order to pursue it, it stops being useful or interesting. If it's a $200,000 dispute, maybe that's a different calculus. Okay. The last of the topics I said I wanted to talk about was ownership. It's only last because it's last. It's not last because it's less important. It's, in fact, the thing that, becomes potentially most important these days, right? So you want to think about what kind of copyright ownership you have when you are working with a service provider, who gets to use it, and how, or who gets that, who gets the right to use the thing that has been created, and under what terms, and how that interacts with how people are paid. So there's a couple little clauses in here, right? So this one says, so this one says, you continue to own, the party who drew them continues to own all their drawings and specifications. In that case, it means they can reuse them from account to account. If you as a service provider, and I guess I'm thinking about, the more likely audience on this call are people who have created things and who are in business to sell those things. In many cases, you're not selling the thing, you are selling, the service of you providing that thing and giving the other side, the customer, the right to use it. So lots of customers will say, well, I paid for it, and so I should own it, right? Without thinking too hard about the fact that what they've hired you for is your expertise that you have developed over years of working on many similar engagements, and that you might be taking aspects of what you have done for others to create a solution for this party. And so not only can't they own it outright, they can't, if they do demand that they own something from you outright, they will prevent you from using anything that you've developed for someone else. So from a service provider's perspective, the best intellectual property scenario is a license to the customer to use whatever the creation is for, as long as you get to decide. You decide duration, you decide geography, you decide any other circumstances that might limit it. But one of the things you can do for someone who wants to own something is to say, I'm giving you an unlimited license to use this in perpetuity, for, in whatever, over the entire world, right? And so, but I can't give you ownership of it because components of that have been licensed to others. And so I don't have the unfettered right to just give it to you. If you need me to own it, right, the price will be 10 times more because I can't use anything that I've used before. I can't use anything that I've used for someone else. And I have to start with a, metaphorical blank sheet of paper and then start that creation process, for you so that you can own it. Nor can I then use it elsewhere. So the value of what I bring, the value of what I get, is more, more limited if you have to own it. So now I need to charge you not 10 times, but 20 times or 100 times more than that. So I mean, when I was I mostly represent service providers. And so but I used to represent only customers. So I understand how that argument's sort of easy to make. But this is another circumstance where you have you can get to the position where you get everything you need, but nothing more. Both parties can do that. And then you'll find that right place to land on this topic. So let me see. Oh, here are the terms, right? Non-exclusive license to use them for the purpose of blah, blah, blah. In this circumstance, because it was an architect giving the owner the right to use, drawings. One of the things you want to do is you want to tie it to being paid, right? So you get that license, but only after I'm fully paid in this circumstance and not before. So, because again, you get everything you need, but I need to get, what I need as well. So the last thing I want to offer you before I conclude is tips for dealing with your lawyers, right? So as I said, there's those my two arrows, one coming at the other. You've got the business priorities and you've got legal priorities. And so you want to make sure that you have a sense of what your business priorities are, so that you can then evaluate what the counsel is telling you. And so give them lots of lead time. How often, I see so often how much lawyers can slow down the process. And sometimes that's on them, but often, they're juggling lots of priorities. Everything's an emergency, so if you give them lots of lead time, you'd be in the best position, to get the most useful help. The other thing is consider those business priorities of yours, but also educate your counsel on them. Clearly communicate what you need, and then say, this is the universe in which I'm asking for your advice. And then, listen to them, respect their advice, consider what it is, push back as necessary, and then the decision's yours. So, get everything you can to be educated from them, understand what they're worried about, take it into account, and then go from there. Thank you. I always enjoy these sessions, and I know there's going to be lots of questions that are going to be interesting. So I'm ready.
All right. So remember that Q&A box is down at the bottom of your Zoom window. If you would like to send in a question that we can ask Jessica, we do have a few already. So the first question is from an attendee who wants to do some part-time consulting, most likely for a municipality or school district, and a one client at a time type of situation. This person is looking for a very simple contract template to list things like the client, business name, few deliverables, the hourly rate, the period the contract covers. Is this something that someone such as yourself can provide, or that you have a recommendation on where to get such a template?
This is an easy one, so I'm going to answer it the easy way, but then answer the question that probably others are having. If you're going to contract with a municipality, they're going to have their own contracting documents, and they're going to require that you use them in almost all cases, right? They're going to have a significant procurement process. So on the one hand, that's easy because you don't have to come up with those, things yourself. On the other hand, you've got to be careful about what you are, what you're agreeing to and how in those documents. I guess the question that's sort of underlying that, is if it weren't a municipality and it were someone else, how is the way, what is the way to do it? Now, I can't give you legal advice without taking you on as a client. I'm ethically prohibited from just speculating about what your circumstances may be. There are lots of good things out there on the internet, but I'd be remiss if I didn't say, consult a lawyer for the legal issues that are, that are particular to your situation. But I think, that aside, if you want to educate yourself, the more things you look at, you will see all of the different choices, you will see the spectrum of ownership, the spectrum of dispute resolution, and liability provisions such as I've, described, and you'll get a sense of kind of what the universe is and what the possibilities are of what you can ask for.
And with this same attendee, do you recommend a certain length of contract time that is reasonable? Is it better to go with a shorter, like 90 days to 120 days to fill out a relationship with a client? Or what advice can you give about that?
So one thing you could employ is contract terms that will cover the relationship for an unlimited or for a longer period of time, and then do particular project plans, statements of work, things that then incorporate those contract terms. So something that I often do a lot is, these are the terms that'll take us through 3 years of our relationship, but only so as long as we have a statement of work in place between us. So now I can do a 2-month statement of work. If that works out, I can start the next one at month 3 and go from there. And then I have already negotiated the over, kind of an umbrella terminology, terms and conditions that will apply for the rest of the relationship. But I'm not, stuck in a long term. That's really interesting. That's a really good question, that someone has the idea. It's a good instinct, the idea that you kind of want to start slow and not, not agree that you're going to be in a relationship for very long until you know that it's the right relationship for you. So that's a way you can do it.
Thank you. So we have an attendee who would like to know more about the term foreseeable and what that exactly means.
Yeah. So foreseeable is one of those terms like reasonable. They're case by case, but they're tied to one another. What would a reasonable person conclude? And so something's foreseeable if you could reasonably expect that it would happen. So New York's got a speed limit of 25 miles an hour in New York City. And, so when I get behind the wheel of my car, I think to myself, like, I really shouldn't speed because I could hit someone, I could cause property damage, personal injury, pain and suffering. Like, there are things that I can foresee happening, right? If you were the kind of person who, like, every day at noon, you went into the same bodega, and you bought the same, like, quick pick lotto ticket, and you were on your way there, as you've done every day for the last 5 years. And that's when I hit you with my car, and then you don't get in to get your quick pick ticket, but someone does get in, and at exactly noon, they buy that, they buy a quick pick ticket and they win $5 million. I'm not responsible for causing you to lose $5 million because it's not the kind of thing that's foreseeable under those circumstances. The same thing works for contracts, just not as maybe memorable. I wanted something that would stick in your heads. So the idea in that circumstance, right, is that, like, I'm not responsible for something that no one could predict, that a reasonable person couldn't predict. Is it a kind of thing that could very well have happened? Sure, right? But it has to be, that the likelihood of it happening was reasonable in order for us to call it foreseeable. And it's based on that kind of fairness thing, right? Like, so we want you to be responsible for everything that might happen from the contract breach, that you could protect, so that you could predict, so that you could protect against it. But nothing more, because it wouldn't be fair, for someone to, put some of those other things on you.
That makes sense. Thank you for that clarification.
Sure.
What strategies can be employed if attorneys are slowing down a process?
I mean, if they're your attorneys and, and they're working for you, the same strategy we get to, to incentivize anyone to do work for us, that said, if you're within that context, is the, some sense of, like, here are the things I care about, here are the things I don't care as much about, can you focus your attention on these things that, you know, are the most important to me. If it's the other side's attorneys, you know, that's just a matter of you know, bargaining position. You can't, you know, if you're in a position to say, I'm going to walk away, then, you know, that's the easiest, you know, or I'm not interested in doing this deal if it continues to take this long. One of the things that I would say, you know, to that is if it is the other side's attorneys, this is a bonus answer that maybe you weren't even asking. If it is the other side's attorney, sometimes, you know, the business people blame their lawyers for it, right? I often tell my clients, just tell them it's my fault, right? That you need to do, you know, that your lawyer insists that you do it this way, you know, or whatever. But a difficult attorney, right, may mean a difficult client and may mean a difficult person on the other side of your relationship. And so you want to think about, you know, like is this deal worth doing under these circumstances? It's often, you know, it can be hard to tease out, you know, is this the thing? But we find this with lots of relationships where the signs were all there in the beginning that it wasn't going to work out, you know, romantic, you know, business, all sorts of things where it's like we kind of knew, but we ignored them. So, you know, if you can, you know, draw from that what, you know, some conclusion about how it's going to be to work in this environment, you may, you know, it may give you some useful information that they didn't even realize they were giving you. And it might make sense to walk away in that circumstance.
Thank you for that answer. This attendee has a question specifically about copyright. So it says, the question says, could you provide a little more info on how a web marketer might use a copyright solution specifically without going to any expense? Or is this far from provable? Like how you would find new sales? And if that, let's see if we can get some clarification. Feel free to that attendee to put some clarification in the Q&A box.
I think Andrew may have jumped on to plug the IP session that's coming up.
Well,
Right?
I guess there's that in part. So we do have a program with the City Bar Association. I'll put the link in the chat on November 1st. I think the date is for a session on intellectual property. But with regard to sales strategies, I mean, there are array of opportunities, I think, in terms of being able to figure out how to kind of more effectively and extensively promote your services. So I think that would fall more into the sweet spot of kind of our business advisors in terms of what we can do to kind of help you engage and think about how to more effectively drive traffic and drive sales for your business.
Thank you. And we have another question as well on new invention ideas and whether a patent is needed. So I think, Andrew, did you want to talk about that one?
I think that also falls squarely into intellectual property. You know, while we skirt on the outskirts of you know, support in terms of operational guidance, legal advice is squarely outside of our mission and capacity. So that's why we engage others who are industry experts in areas such as this. So I would recommend you join us for our intellectual property rights session on November 1st, and hopefully that'll be you know, I'd be able to address that specific question.
Agree, but I will say, just looking at that question, if that's the going to sell my new invention ideas, ideas aren't copyrightable, they're not patentable until you achieve some formalities to them. And so you do want to make sure you educate yourself so that you understand what it is that you have to do in order to protect those rights. And you know, your question is, do I need a patent? You know, maybe. Do you need a, you know, you might be a copyright. Lots of you know, nomenclature around here. You know, people don't, they're not even sure what they need. They just know they've created something and they've got to figure that out. So the idea can't be protected, but the specific way that you can do something can absolutely be protected. And you want to make sure that you know, take those steps before you interact and, share share that creation with others, because in some cases the timing matters. Yeah. So I recommend that session highly.
Wonderful. And the person said they are already registered for November. So
Perfect.
hopefully you will get lots of great information in November at that session. All right, we have another question. What can be done if the parties continue discussing details of the agreement which are not substantive to the transaction and slow down the process? How can someone facilitate reaching an agreement between parties in that type of situation?
I'm not sure I understand if you're talking about things that aren't substantive. I'm sure I'm missing something, because of course my answer is we'll stop talking about those things and and sign the document. So I'm not sure. It may be a situation that comes down once again to kind of who wants it more, right? If I'm slowing down the process, it may be because I'm just not as interested in moving forward with something, or I'm not interested in moving forward on your time or on your terms. And I may be interested in moving forward, but just on the, in the way I'm doing it. Oh, I see they've put up a clients cannot come to an agreement. Again, that's one of those things. If you can't come to an agreement on things that in your view are not that important, right, or not substantive, I'm not sure why you're doing business, right? How do you, the very nature of putting together some kind of relationship is that you have a sense of where you, how you want to be and what the terms are for, what the parameters are for that relationship. If you can't come to an agreement, then you haven't indicated that you're both willing to move forward. It can often be, maybe this is the perfect, I see we're at 4:02. It's like sort of maybe the perfect thing to end on, really, right? If clients can't come to an agreement, then they haven't, they haven't had a meeting of the minds, and they don't have a sense that these are the terms that they're, willing to abide by and willing to be bound by. And the whole point of the of contract law, sure, it's for bring the full force of the the state down on someone who doesn't do what they're supposed to do, but really it's to set expectations between us so that we know how we can work together harmoniously. That's the goal, right? It's not really it's the idea that if things don't go well, I'll be able to have a remedy, but it's really, to set the parameters for what would be going well. What do you think going well would be? What do I think going well would be? And that's how we determine, that we've got a relationship that's going to work for us. So there you go.
Thank you. And I just want to relay that we've had several thanks come in for the presentation. Awesome. So one of our attendees also pointed out very accurately that uspto.gov has excellent information on intellectual property matters, and they do have a wealth of information on that website. So always a good place to go to find out some more information on some of these intellectual property questions that we've had today. So we will.
If you're going to plug the PTO, then at least plug the copyright office too, right? Because PTO,
yes,
trademarks. So yes, copyright office. Yep.
Yes, thank you for that. And thank you for this wonderful presentation, and for everyone who joined us today. You will receive a follow-up email with a link to the recording. And we kindly ask if you have a few minutes to give us feedback in the webinar survey that displays after the webinar and will also be linked in that follow-up email. Andrew, did you have any parting words for us today?
Parting words. Well, I wanted to, again, Jenny, thanks as always for your partnership on this, and Jessica, terrific presentations always. Really appreciate working with you and your insightful comments. And to all of you, the attendees today, I hope you got a great deal out of this. I think there's a lot to be learned, I think, and hopefully you'll take advantage of upcoming training sessions we have, as well as connecting with a SBDC business advisor, either here in New York City or wherever you call home. So thanks for joining us, and have a great rest of the afternoon.
Yeah, yes. Thanks everybody.
Thank you. Bye-bye.
Bye.